I must mention, it's not very often that we have empirical studies happening in law school. So very insightful that is. Could I now invite Chauhan sir to express his opinions on the talk?
So I'll just limit my comments to issues that have been specifically flagged. And if there is a certain degree of repetition, well, that's what lecturers tend to do. So Alok's broad argument is that the crisis of credibility in the Indian courts is not something that has occurred in the recent past. It appears to be a consequence of a set of reasons which have unfolded over several decades. And in the course of his talk, he concentrated on three reasons, right? The first being the problems of capacity or the lack of it, which makes it hard for courts to keep up with the caseload or to dispose of it efficiently. The second factor being the Supreme Court's diminishing role when it comes to constitutional adjudication. And the third question, which is perhaps a broader discussion in access to justice, on whether litigants are perhaps consciously choosing to stay away from civil courts, right, if not criminal courts, depending on how we read the data. So I'll try to comment briefly on the supporting reasons that he has given, and maybe also add a couple of pointers to maybe talk about the research that is already happening in other parts of the world, and the kind of research that we can be doing in a meaningful way in the immediate future. So on the question of capacity or incapacity, the public discourse in the recent past at least has concentrated on the vacancies problem, and Alok also used that frame. So very briefly, if you want to analyze the causes for a high rate of vacancies, let's say beginning with the high courts, we can briefly say that the major concern seems to be that of opportunity costs. And the reason I consciously choose to use that frame rather than talking about the inefficiency of the collegium is because the problem of opportunity costs has actually amplified a lot more in the last 30 years, as opposed to the more limited debate about the role of the collegium. So there I'm in complete agreement with what Alok was saying, that it's a tad bit unfair to say that the present government is slowing down appointments or is deliberately sitting on files which are sent by the collegium. The collegium might be adding to the inefficiency in the process of appointing judges to the high courts and then for promotions to the Supreme Court. But by no leap of logic is the collegium the primary reason for delays in filling up judicial posts, right? The structural reason seems to be more at the stage of selection itself. And it's something that you've heard repeatedly inside the classroom and outside the classroom, that very often the best known lawyers don't want to become judges, right? Which is why I'm using the phrase opportunity costs, that invariably becoming a high court judge when you're in your mid-40s would mean that you're foregoing a substantial amount of income that you could be earning, right, if you continue with private practice. You will be bound to retire by a certain age, which of course leads to its own complications, which we'll get to, because Alok did talk about post-retirement jobs. But at a very simple logical level, right, if you know that you're going to retire at 62 or 65, why would you forego the income or the prestige that you could earn by working as a private counsel, possibly into your 80s, as we see in many examples? And a third aspect of opportunity costs is the question of transfers. Once you become a high court judge, effectively there's an expectation that with career growth, there will also be an obligation to accept transfers. And there might be many practitioners who would be reluctant to relocate from their respective high courts. So this is very obvious, right? Now, we don't really have rigorous data to explain why these opportunity costs have actually maybe discouraged the best talent from approaching the bench. But certainly it's a safe statement to say that an incumbent collegium will find it difficult to persuade the leading advocates of that high court to become judges in the first place. So I think we should give due credence to that argument and not really focus too much on the recent discourse which says that the union law minister doesn't like what the judges are saying, the judges don't like what the union law minister is saying. That's perhaps an episodic reason, right? So we need to be able to differentiate the structural reasons from the episodic reasons. So I think in terms of conducting serious research on it, it would be more useful for us to perhaps collect data at the level of each high court and see why is it that the better known lawyers or the lawyers with a established pedigree are reluctant to join the bench. I think that would be the kind of meaningful research which can add value to this discussion. In terms of the current problem, of course, I don't think we've come close to such a situation in the past, where you have more than 400 posts in the high courts which are vacant. You are seeing protests by lawyers and bar associations in different states, and there is no indication that the situation is going to improve in the next year or two. So if you survey the literature, there are all kinds of suggestions which have come But in the long run, it's unlikely that any of these suggestions are going to be acted upon, right? Some people say that you should ordinarily just increase the retirement age because that would perhaps expand the pool of judges who are available to serve in the high courts and would essentially postpone the retirements that are likely to happen. Some people say you can rapidly scale up high court appointments by simply appointing younger people, right? Rather than adopting an informal criterion which privileges previous experience at the bar, why not take a risk and appoint younger practitioners or promote more people from the lower courts? So all of these are suggestions which are being thrown in the air, but we don't really see any concrete action around these suggestions, right? So does the same problem persist at the level of the lower courts? I think not, right? Because when it comes to the lower courts, if you look at it purely as a supply and demand problem, you do have a large number of applicants appearing for judicial service examinations in different parts of the country. Being situated in the NLUs is actually giving us a distorted picture, and especially being situated in a school like Nalsar gives us a distorted picture, because a substantial number of graduates from here will not really think about careers in the lower judiciary. But if you were to look at a representative sampling of law graduates from the larger state universities, you do find that a substantial number of people are interested in applying for positions in the lower judiciary. So should we see this issue simply in terms of a gap between supply and demand, or should we concentrate more on administrative delays and litigation, which was the reason that Alok was flagging? I'm sure he was not saying that's an exhaustive reason, but certainly there are numerous other reasons which we can bring to the table to analyze why there might be a higher rate of vacancies in the subordinate courts as opposed to what has happened in the past, right? So I think the recent data shows us that the vacancy rate at the national level is anywhere between 25 and 30%. And in some states, the vacancies in the lower courts are actually much higher. So is that a function of just a state government ignoring the process because they don't hold the recruitment process regularly, right? Or is there something else which has to be added to the story in terms of just the time taken for conducting the examination, conducting the interview, and then of course facing up to the litigation that invariably happens where losing candidates are aggrieved by the process. So I think that's an area which requires a fair amount of research. In fact, for those of you who are interested in civil justice, the Vidhi has come out with a report in November, which tries to examine how different states are doing when it comes to recruitments to the subordinate courts. And I'm sure that even at Nalsar, we can certainly incubate more serious research which looks at lower court appointments, right? Maybe we could start with Telangana and then see what kind of data is available, and if possible in the future, scale it up and look at how these processes are unfolding in other parts of the country. So very quickly, just on the functioning of the collegium, because I can claim to have some insider knowledge. My first job was as a law clerk to a former Chief Justice, not the best known Chief Justice, right? But this entire point about the collegium not being able to track potential appointees, I think is a point that also needs to be countered to some extent. So I'm not necessarily disagreeing with what Alok is saying. In fact, the consistent argument of this kind has been made by Prashant Bhushan for many years. As you might know, Prashant Bhushan is also part of an organization called Campaign for Judicial Accountability. And he has persistently made this argument since the collegium system came in the early 1990s, that how can you expect a small entity which is attached to the Chief Justice's office to keep track of the hundreds of potential appointees who you might want to consider for selection to the high courts. So he was making a simple argument that a small staff of 2 or 3 people assisting the collegium judges is simply an inefficient way of screening candidates for appointments to the high courts. So I would actually try and add a bit more depth to that point by saying that it's not just the collegium which is keeping track of potential nominees, but you actually have a department in the Union Ministry for Law and Justice called the Department of Justice, right, which is supposed to be performing this tracking function. So in terms of personnel or resources which need to be made available for identifying potential nominees, for adding more feedback to the process of selection, right, there are administrative mechanisms which are in place. But the question is, how well is the collegium coordinating its activities with the Department of Justice when they look at a fresh file for nominating judges, right? And I can give you some first-person accounts of how some appointments came through a few years ago, but then of course we are recording, right? So, but what I'm trying to say is this argument of inefficiency is perhaps not the most serious argument, right? And think about it in terms of comparisons with other sectors, right? People will tell you, look at private recruiters, especially in the IT sector. They recruit thousands of people every year by visiting campuses, by holding public processes of selection. Look at public sector undertakings themselves, who recruit talent which is graduating, which has experience. So why is it so hard to recruit people to the judiciary, right? So I think the coordination question is something that can be easily addressed, provided that you have a sort of you have a harmonious interaction between the Department of Justice and the collegium, and the collegium, even if it is manned by a few personnel, can easily rely upon the resources of the executive branch, right? But that takes us to the more difficult question of what happens in a situation like the one we are seeing now, where there is considerable distrust between the executive branch and the courts, right? So it doesn't really matter how many personnel you appoint to keep track of who is in the respective age range or who has a worthwhile practice to consider for promotion, right? All of these things may come to naught when your incumbent minister or your incumbent cabinet may actually want to be on the confrontational path with the judiciary or vice versa. So that's of course an issue that we do end up talking about in our constitutional law classes, but I think it's also important to get a sense of how these processes work in real time. Can serving justices meaningfully devote time to appointments? Moot question, because a lot of people will see the prestige of the collegium more in terms of the power to appoint rather than the fact that you are a senior most judge in the Supreme Court. So this is again something that you can verify through interviews with retired judges or serving judges, that the powers that are conferred on the collegium judges, of course, can be looked at in a negative way, because once you enter this group of the 5 senior most judges, you effectively get a veto over who gets appointed to the High Court, who gets elevated to the Supreme Court. So it does undermine the presumptive federal character of the higher judiciary. But on the other hand, the power to appoint can also play a very constructive role, right? Those who are genuinely concerned about the quality of judgments or who are genuinely willing to invest time in screening potential appointees can actually use this power very meaningfully. So I would be a bit of a fence sitter when it comes to the question of whether the collegium is the right model for making appointments to the higher judiciary, or whether you should adopt a mechanism like the NJAC, which is effectively where the government had come up with a proposal of involving the executive also in that process. So that's perhaps a discussion for another day, because that takes you into much deeper questions about the history of appointments, the historical evidence of misuse, especially in the 70s and 80s, and the kind of equilibrium that we have tried to work out, right? So I'll skip commenting on that, because then that becomes a different thread by itself. On the shortening terms of Chief Justices, yes, it's true that the average term of an incumbent Chief Justice seems to be declining over the last 30 to 40 years, but that's largely a function of adhering to the seniority norm, right? So if you have a mandatory policy of Chief Justices retiring at 65, and then the next Chief Justice being chosen on the basis of seniority, then this is going to be the logical consequence of that policy. So unless you come up with an alternative for, let's say, an alternative like fixed tenures for incumbent Chief Justices, or a principle other than seniority, I don't see how we can get around this problem and change status quo, right? As long as you think that seniority is the most neutral criteria for ensuring promotions and elevations within the Supreme Court, we are likely to persist with this problem of shorter terms. Maybe Alok might have some other ideas, so maybe we can debate that in the discussion. Coming to the second claim, which is on the Supreme Court not performing its constitutional role, I think Alok gave us a pretty good summary of some of the literature which has made this point. So I actually had helped Nicholas Robinson in collecting the data for his paper on the Supreme Court's caseload over a 2-decade period. And Alok showed you a slide for 2014, but we were able to piece together data between 1993 and 2011, which is, by the way, going to be mandatory reading for the seminar students, right? If you're not interested, you will have to be, right? The paper there shows clear evidence that special leave petitions have been the dominant part of the Supreme Court's docket since the early 1990s. In fact, if you create a time series data set and go back in time, the real jump in the proportion of special leave petitions happens in the early 1980s itself. So apart from just capturing what is happening right now, it's also important to understand the historical context for the rise of the SLP, if that's how you can remember it, right? So the current data which Alok was showing you suggests that more than 80% of the inflow into the Supreme Court consists of special leave petitions under Article 136, which is basically a remedy that was thought to be an exceptional remedy at the time of the framing of the Constitution, right? At the time that the Constitution was being framed, the rationale for including this power was that, look, we still have some British appointed judges who will continue in service for a long period of time. So we need a power of corrective intervention when, let's say, judges loyal to the British Crown give decisions against the government. And then, of course, there is a more nuanced point being made in the assembly debates about why the Supreme Court does require a power of this kind to be used in exceptional cases to protect rights. So compared to that original argument for including the power of Article 136, we clearly have an anomaly where the exceptional power has become the norm. And invariably, if you're a practitioner before the Supreme Court, if you're an advocate on record who's filing cases regularly, most of your cases are going to be in the form of a special leave petition. So I would say now our attention should shift from the normative function of a special leave petition to the livelihood concerns of the special leave petition, because invariably for most people, filing a special leave petition is more a means of earning income rather than actually ensuring a tangible outcome for their clients. So that leads to other pathologies, right? Are judges devoting enough time to each case? Are they considering cases on merits? Which takes us to the next sort of finding, that most cases that are being filed in the Supreme Court are being dismissed in limine, right? So since many of you are year 1 students, in limine is simply deciding a case without assigning reasons, right? So obviously you come across in limine decision making in different contexts, especially on the administrative side. A large number of decision making is not backed up by reasons, right? Which is why gradually courts will start scrutinizing decisions made by administrative bodies and impose a reason giving requirement, right? But invariably, when you look at Supreme Court litigation, a large chunk of cases are essentially consisting of proceedings where files are literally thrown back at the lawyer who's standing before the bench. So some of you who've interned this may have seen this very literally, and it's a very good image to help in communicating the possibility of in limine disposal. That invariably it doesn't really matter what the lawyer says. Benches have already made up their mind about what they're going to do with the case. So I hope you can see the connection between the predominance of special leave petitions and the increasing tendency of sitting judges to dispose cases off in an in limine fashion, right? If I was an individual judge and I had a heavy caseload of 70 cases on a miscellaneous day, on a Monday or Friday, right? My own priorities would be to sift through and narrow it down my caseload to the few cases where I think there are important questions, and I'll try to quickly process the others, right? So in that sense, a apex court judge is behaving more like a petty bureaucrat who's simply trying to get rid of the workload in front of them. So invariably, that analogy is something which actually is playing out in the recent past in the Supreme Court's history. It wasn't always like this, right? If you go by the accounts of lawyers who are much more senior than the present generation, or by written accounts, you did have a time where the Supreme Court sat in larger benches, right? And there was considerable deliberation even before a short order was issued inside the courtroom. So you do see a clear change that has happened on a decadal basis, where not only is the overall number of cases increasing, but because of this larger increase, you also need to change the bench structures. Rather than relying on 5-judge benches and 3-judge benches, there is a presumption that cases will first go before a division bench. And then I think Alok explained quite well why the power dynamics within a division bench may be quite inferior to the possibility of a case being heard by a constitutional bench. So is this evidence of a crisis of credibility? I mean, I'd like to contest that on another date, because many people would say that given the needs of a large and expansive country like India, where you are bound to have an increasing caseload at the appellate level with the passage in time, the court perhaps had no other option but to think about its decision making in these fragmented benches. So you've had some recent proposals in this direction as well. Mr. Venugopal had famously argued for splitting up the constitutional functions of the court from the appellate functions of the court, and his suggestion was that the Supreme Court could possibly sit in regional benches in 4 or 5 different parts of the country, and the Constitutional Court could be a separate entity, right? That was a suggestion which some others have also weighed in with, right? Others say that look at the text of the Constitution itself. Article 130 of the Constitution actually allows the Supreme Court to set up circuit benches or benches in other parts of the country, and in fact that power has been used once, right? In fact, in the early years of the Republic, and that bench of the Supreme Court was set up right here in Hyderabad to decide claims that were arising from the confiscation of property after the Nizam's rule had ended. So that's a bit of trivia, right? So nothing prevents the current Supreme Court from deconcentrating itself and saying that if we've got 11 or 12 benches, we can actually park our benches in different parts of the country, so that it might actually reduce the transaction costs and the spending which litigants and lawyers have to incur to approach the respective forums. Now, this idea is not an unheard of idea, because you do have other countries in the world where the federal judiciary does have regional panels, right? So it's something which is conceptually possible, but obviously there are a large number of reasons offered by people within the system which would be contrary to it as well, right? Some people would say that if you were to disaggregate the Supreme Court into regional courts of appeal, that would take away from the prestige or the authority of an apex court, and that would also lead to inter se conflicts about case allocation, right? But in the larger scheme of things, it's perhaps an idea worth considering, and maybe a future government may find the courage to do so. Though what I'm suggesting is that on paper it is possible for the Supreme Court to use its own power and constitute benches at different locations. So this is certainly a question that can be researched with a bit more depth, and certainly with better references to other parts of the world, right?
The biggest problem against this is the lack of Lucian's bungalows.
Yeah. Okay. So what Alok said is that if you did deconcentrate the Supreme Court in a hypothetical future, let's say in 2050, when people like us have retired, and you might be at the peak of your career, he says the biggest problem would be that we don't have Lutyens bungalows in Calcutta and Bangalore and Bombay, right? So we need to create those accessories of power before people will agree to a division.
My solution to that is to level the existing Lutyens bungalows.
Right,
not
okay.
to build more.
Right. So one solution is that each Lutyens bungalow can accommodate about 20 apartments, right? But we need a socialist government to do that. And given the current state of electoral politics, I don't think we are getting a socialist government anytime in the future, right? Maybe the 22nd century, right? So coming to the last sort of aspect, which I think is a more structural sort of discussion, not confined to the higher judiciary, but perhaps is touching on some deeper threads in our understanding of justice delivery. So Alok did touch upon post-retirement jobs, which many people would hesitate to describe as an explicit form of corruption, right? So I know maybe we can debate the formulation of that argument, but this assumption that people are effectively on sale because the union government may consider you for appointment to a tribunal or a regulatory authority or a high office after retirement, I think is also a claim which requires some critical scrutiny, both from within and outside the judiciary. One counter argument that I've heard a lot in Delhi circles is that if you do need personnel to man many of these tribunals or to occupy these posts, who else will you reach out to, right? If you rely on career bureaucrats, the situation is going to be much worse. So if you do have specialist tribunals which are perhaps looking at service disputes, electricity disputes, tax rulings, and other such functions which are broadly covered by tribunals or regulatory authorities, there is a common wisdom that it is people with judicial training who are attuned to the norms of adversarial argument who are actually better suited to perform this function, right? Whereas if you left the tribunals in the hands of retired civil servants, the situation would be far worse. So I would offer a counterpoint to the entire discussion on post-retirement jobs, that it might be creating some apprehensions about serving judges favoring the incumbent government because they expect an opportunity as soon as they retire, right? But the counter argument is that if you don't pick from this pool of people, the outcomes are going to be much worse, right? And we've already seen elaborate discussion of the revolving door syndrome in our country, right? The revolving door is effectively that as a bureaucrat or an official, you've been involved with regulation of a particular sector, but after giving up public office, you can actually join that private sector and be a player in that particular sector, right? And it can also work the other way around. When you have nominated positions or the possibility of bringing private sector talent into the government, you could have somebody who's been a participant in a certain sector, then being brought into a regulatory role. So there's a fair amount of literature on this in comparative administrative law, but it's certainly an issue which requires more careful attention in the Indian context, right? Prashant was half thinking about writing a book on that theme, but maybe that theme will be discussed a bit more as we spend more time on those topics. So the question for me is not the idea that post-retirement jobs per se amount to corruption, but are there institutional safeguards which can help us work out a middle solution? So for instance, could there be a waiting period, right? Before a retired judge is considered for appointment to a particular tribunal or a particular administrative authority which requires somebody with a judicial temperament. So I'm trying to present both sides of the argument here, right? Or if not a waiting period, could you preempt the entire discussion by simply increasing retirement ages, right? So some radical solutions that we've heard of in this regard are, why don't you simply give retired judges the protection of pay, which is basically whatever pension, whatever their last salary was, right, can be assured to them for the rest of their lives. Which means that it would reduce their incentive to actually seek income earning opportunities or to even curry favor with the government. But once again, you can have a counter argument and say that, look, if you're going to be in a statutory role or a constitutional role post-retirement, that might actually carry far more rewards than, let's say, pay protection for the last salary drawn, and it may not really be an effective measure. So this is certainly an area where we can do more research. The slides at least showed you the data which Vidhi has collected, which is largely based on, I think, incumbents who are in the different levels of government, whether it is state level tribunals, central government appointed offices, but we could certainly do a longitudinal study which tracks this phenomenon of judges taking up career options post-retirement over a longer period of time. In fact, if one really has to go in the direction of corruption, we should not be confining ourselves to public sector appointments, but we should perhaps also pay a bit more attention to the market for commercial arbitration, right? Now, this is the bogey in the room, because many of you will have livelihoods which are going to depend on commercial arbitration in a few years from now, but maybe some serious research is called for to examine the kind of people most likely to be appointed as arbitrators, especially in ad hoc arbitration in India, and the kind of payoffs that these individuals get for the quality of work which they do. And if you've assisted any lawyer in an arbitration, you'll know that there is a lack of proportionality when it comes to the quality of work and the kind of money that is being paid. But again, no name should be taken, right? The last theme which Alok touched upon, which is the clear gap in the rate of appeal for civil cases vis-a-vis criminal cases. So he's given us part of the answer, right? And one part of the answer is that, look, if a criminal case is decided by a sessions court or a magistrate's court, it's very likely that there will be an appeal against the decision of that forum, right? If you're the defendant who's been convicted, you're likely to file an appeal against the conviction or appeal against the sentence, which is now possible under the CRPC. Or if you're the state and if you're dissatisfied with the sentence given or there's been an acquittal, you will have a good reason for you to go and appeal. So you could say that Alok's explanation explains that part of the puzzle. That when it comes to criminal cases, parties don't really have effective agency over the question of appeal. Whereas in civil cases, the question of appeal is largely left to parties' own hands. So he was suggesting that the data over the last decade or so shows that the rate of appeal in civil cases is actually declining, right? As opposed to a progressive increase, which you would expect in any society where population growth is happening and where economic growth is happening, right?
Yeah. Not just state of appeal, even original suits, even approaching the court on your own for a case, front up, because the High Court jurisdiction includes original civil jurisdiction as well, right? You include writ jurisdiction. So that is what I was sort of.
Okay, thanks. Yeah, thanks for clarifying that. So the broader argument seems to be that the rate at which people are approaching civil forums, whether in the original side or in the appellate side, is not really correlated with the population growth or the growth in economic indicators, which is the intuitive presumption that you would make, right? If you were tracking litigation rates in any country in the world, you would assume that a larger population and a higher index of economic growth will be correlated with an increase in litigation rates. Whereas when it comes to the situation of civil courts in India, we seem to be finding evidence to the contrary. So this was the finding made by Theodore Eisenberg, Sital Kalantri and Nick Robinson in a paper. So that paper itself is a bit controversial because sometimes the causal links between litigation rates and socioeconomic indicators aren't clear enough, right? And let me just spend a couple of minutes on that before we move on to questions. Would a highly literate society be more likely to be, would it be more litigious or less litigious, right? It's a question worth asking, right? If there are high levels of education and literacy in a particular society, is it more likely that people are going to be more aware of statutory rights or civil remedies, right? Are health indicators going to be closely correlated to litigation rates? A particular state might make massive investments in public health and provide a robust infrastructure for medical services at the grassroots level. But is there actually going to be a connection to litigation rates? I mean, if you take the example of socialist countries, you would actually find a contrary example, right? Countries which have made massive investments in social welfare may not be actually witnessing an increase in litigation rate at the same time, right? Similarly, if you look at broader socioeconomic indicators like malnutrition or how effectively the government is combating these problems, right? There is a larger debate in this field. If you look at the access to justice literature, where there are serious doubts being cast on the causal links between socioeconomic indicators and rates of litigation. So that's just a preliminary point I wanted to throw out there, right? Not necessarily disagreeing with what Alok is saying, but just to give it a sort of broader plank. But when we come to the Indian context, if we assume that there are clear links between socioeconomic indicators and litigation rates, we seem to have evidence to the contrary. So I would say there might be other reasons why this might be happening, right? So one is, of course, that people are frustrated with the delays in civil justice, and hence they choose not to appeal or not to even approach the civil court in the first place, right? But there is a longer story which is connected to it. And this is something that we've tried to cover in our seminar, where we think about the possibility of strategic behavior by litigants at the grassroots level, right? If you are involved in a property dispute or you're involved in a partition dispute, which is very likely to happen in the context of a large Indian family, right? Who is going to be your first forum? Is it going to be elders in the community? Is it going to be a caste panchayat? Right? Is it going to be a professional mediator? Perhaps not. And at what point are you going to make the decision to approach a civil court? Right? And even if you have made the decision to approach a civil court, there could be several contexts where the very fact of litigation itself attracts social disapproval. So this is where your engagement with law and sociology or sociology of law becomes more important. Because it's not enough to maybe track this issue just in terms of litigation rates which are tracked with formal mechanisms, because you might have a large sector of disputes, a large segment of disputes being addressed in informal forums which are very hard to measure. Now that discourse might be changing a little bit, especially with the institutional emphasis on methods like mediation, but remember that's a very small slice of the pie. The only evidence that we might have on the growth of mediation is coming from some urban centers, and even that evidence is telling us that this is invariably happening only in the context of family disputes, where there's a very clear unequal bargaining power between women and men, because invariably, even if women have taken cases to court, there will be pressure on them to divert them to an inferior forum like mediation. So there is a slightly more advanced discussion that needs to happen when we start thinking about the causes for the decline of civil justice, right? Another reason which I couldn't really correlate with Alok's data, but is worth considering is what has happened with the fragmentation of forums on the civil side, right? With the passage in time, and this maybe requires data going back to the 50s and 60s, has the establishment of newer tribunals and the creation of more specialist forums simply taken litigation away to these other administrative forums, which means that the same kind of cases which would otherwise have appeared as part of your civil justice docket are actually appearing in other forums, right? So sometimes you could have a statute which basically takes away the jurisdiction of the civil court in a certain area, and there is an administrative forum which now becomes your primary forum for initiating any dispute settlement process. So that's the intuitive response to his evidence, because the evidence is more recent, but that's certainly something that is worth researching with a bit more depth. And the last point about corruption by judges, once again, just like the mythical figure of a judge who accepts bribes, it's always easier to convince people that the judge is corrupt rather than convincing them that the position that they've taken is actually wrong. So if you go with a discourse analysis of popular media sources, I think the problem is being overplayed, right? There is of course intense corruption of different forms, ranging from direct forms of bribery to influencing judgments from time to time. But I think we should cut some slack to people who are professionals in the sector, and also acknowledge the fact that there might be many people who may be doing their work with honesty. So once again, you need hard evidence to make claims about corruption, but sadly, much of the allegations of corruption, most of the allegations of corruption have more to do with misconduct by lawyers rather than sitting judges. And the possibility of investigating misconduct by lawyers is a different story altogether, right? Because the bar councils are supposed to play a disciplinary role, but effectively when you see the number of cases that are filed before the disciplinary committees of the bar councils, the numbers are minuscule. So that tends to happen when you have an elected body which is also performing a disciplinary function, right? If you're going to rely upon the same constituents to gain support and then win re-elections to the bar councils, what is your incentive to actually take strict action when cases of misconduct are being reported? So which is why you have an anomalous situation where lawyers beating up Kanhaiya Kumar have not really faced any consequence at all, right? Whereas Dushyant Dave, who has courageously taken on the center on Judge Loya's death, is actually being sent notices by the Bar Council. So that's a different story altogether, which we didn't get into, but certainly when we look at the ethics of the profession, that's certainly a major issue that we need to look at, right?
Let me very quickly respond to a few points. Let me just very quickly respond to a few points, and I don't fundamentally disagree with what Siddharth Chauhan has said. So I'll go backwards from the points that he made. With regard to tribunals taking away caseload, so this is something which we did the research on, but we got the data in a confidential capacity, so we really can't reveal it in public, but I can give you some broad ballpark figures. Most of your tribunal cases are in the ITAT and CESTAT, a bulk of them, right? And they're in the order of the lakhs. There's a number of cases filed are in the order of tens of thousands, pendencies in the order of lakhs. So these have been long-standing tribunals, so it's not a recent phenomenon of cases going out of the courts to the thing. All the newer tribunals, to put together, they may be about 30,000-40,000 cases a year. So that change is not so dramatic. So which is what I actually discuss all of this in my paper in EPWs for that.
If I can clarify, so what about other civil forums, like labor courts consumer dispute forums.
They will come in this figure. Consumer forums may not be, but consumer forums as such, that state level thing is not very clear. But I would still say those are in the orders of maybe a few lakh. But it doesn't account for the dip. At least there should be some post-retirement jobs. See, one point that I thought I didn't offer a solution. I would think one solution for post-retirement jobs is pick lawyers. If you say, it was also to lead into the point that if the collegium is going to a problem, show that the government and the collegium can sit together and pick good lawyers for tribunals at least, if not for high courts. Fine, you have a certain high level for high courts, but surely you should be able to pick competent lawyers, because actually under the law, in most cases, except for a few tribunals here and there, you can appoint lawyers qualified to be high court judges to those tribunals, and unfortunately they're not tapped. With regard to the Chief Justice thing, yes, I actually say that, see, even within the collegium, it's possible to pick a Chief Justice who will have served for at least 2 years, right? Even if you follow the seniority, you can keep this in mind while picking, that we want somebody, and of course you can make rule changes afterwards. I'm very wary of leaving it to the DOJ. Having been a government counsel for 4.5 years and dealing with the law ministry, I can say that it is one ministry which has not distinguished itself in any way possible. It would be better off creating a body like that to assist the collegium. You would want a body which is capable of taking that information, capable of taking and maintaining that information in a sustained manner and not be caught up with the regular intrigue that goes on in the law ministry. So that is the suggestion. With regard to subordinate court judges, I think you sort of made the point about appointments. Yes, you do get a lot of people applying, but just one point which I didn't make, and I thought I just respond is that the issue there is of the quality of the legal profession and the education, which I didn't want to go into in too much detail because that's another 45-minute talk if you honestly ask me. There is a situation where you get 100 applicants and only one will clear the exam. Forget about 100 applicants for one post. After 100 applicants, only one will clear the examination. There's effectively one person for that one post. More so in the higher part of it, right? For the lower half of the subordinate judicial, not so much, but in the higher judicial service, is one person for one post. There's another thing more than, and this is also something that I didn't discuss, I didn't have the time for this. There's another actual aspect which sort of deters people from applying for subordinate judiciary posts, is that they're not given enough chances to be high court judges. Now, which also leads into my point about opportunity cost. If top lawyers say no, there's nothing preventing the High Court from saying it's okay. We know which subordinate judiciary folks are retiring in the next 10 years. We know the top 10 senior most judges in the district judge level. Let's make them High Court judges. No, I know that there are issues of quality there also. People complain that they're not good enough. But whose fault is that? It is really the fact the High Court has put no effort into ensuring the brightest are promoted, right? There also promotions seem to happen almost on the basis of an ACR and all that, which really nobody really applies their mind to. You're not giving a lot of them opportunities to improve their skills, to become good in what they do and go beyond. And then High Court judges will complain, or district judges are not. There is, I think, and if I can be a little controversial, there is a certain element of class and caste here. If you notice, the subordinate judiciary has a level of diversity that is much higher than the High Court. Why? Because subordinate judiciary, there are usually reservations, and you ensure that at least there is a certain percentage of judges from scheduled caste, scheduled tribes, from women, and so on. But in the High Court, where it is pure discretion of the 3 judges plus the collegium, you find that the numbers drop dramatically, right? And that to me suggests that the filtering mechanisms being applied in saying this person is not good enough needs to be critically rethought of from the lens of caste and class and gender. And which is, again, another topic for another 45-minute discussion. I won't go into it in full detail.
There's been a raging controversy in Tamil Nadu,
right,
over the question of diversity in the lower courts.
In Karnataka also, for that matter, I can say that. So yeah, you're absolutely right. Increasing the length of service, if I can just add, the people who oppose the increase in the length of service the most vehemently are judges themselves. Almost every judge towards the end of their retirement saying, if I had to do this for another 5 years, I will resign. To be fair to them, it's a stressful job, it's a hectic job. And any conscientious judge will work far harder than most of your first year law associates trying to pull 100 hours a week. And I'm sure Siddharth will attest to that, having worked with the judge. It is a very stressful job, and it is possibly, difficult for them to extend. But yeah, there are like 10 topics for research and what we just discussed in the last 1.5 hours. So it'll be great if somebody takes it up. So I think we can open it up for questions.
Hello. Hello. I'm advancing these arguments to make a claim that Vidhi has a lot of researcher bias. Now, when we made a claim that when the judges are tend to retire, they make the judgments, there's a bias towards the favor of union. Now, did we categorize the categories of judgment? Let's take first category, where the case is decided on merits. Type 1, when the case has a significant effect, Aadhar. Type 2, where the case has a negligible effect, like the union should pay 50,000 more compensation. Category 1. Category 2, when the case is dismissed in limine. 1.
No, sorry, let me very quickly cut you short there. You're referring to Madhav Ane's piece, and he has a very specific definition of significant cases, which addresses exactly the point that you're making. So I'd suggest you sort of go through that piece. He defines significant cases. He doesn't bring into the question cases of in limine or small amounts of things. So just go through that, because that will answer the question again.
I will certainly read that, but it's a very pointed question. So
it's not a Vidhi paper. It's not a Vidhi paper. Sorry, it's a paper by Madhav Ane, Shubhankar Dam and Giovanni Co. It's called Corruption in the Judiciary. You should find it on SSRN. So if you look at that paper and go through it in some detail, you will find they explain their methodology. I didn't have the time to go through it in depth, but you will find them explaining the methodology.
So I'll read that. I'm only asking, when we came up with the 80% of the data, so did we categorize the categories into these heads?
So if you see, again, I'll refer to our report on the effectiveness and efficiency of the Supreme Court. Again, there we've gone into which cases were dismissed in limine, which cases were taken up for further hearing, and what subject matter of the cases also. So we found that even with regard to SLPs, the vast bulk are regular civil cases, are service cases, are tax cases, and labor cases. So they are not exactly cases which deal with significant questions of law.
In fact, if I may add, so even in the numbers that we were able to put together for that 18-year period, we found a clear subject matter bias.
Yeah.
So that doesn't really have anything to do with post-retirement jobs, but it does perhaps raise questions about the background of judges themselves. Right? If I've been a private practitioner with some exposure to arbitration law or labor law or tax law, then am I more likely to privilege those cases when I'm deciding on admitting them for a hearing on merits and eventually devoting time? So we didn't really explicate those arguments, but that's why the numbers are out there. And part of Prashant's project is to try and investigate those claims further. Right?
By the way, just one area, if I can just very quickly add before the next question. One area which we've been hitting a consistent dead wall every time I'm thinking of a project is arbitration. Empirical research in arbitration seems almost impossible. Negligible, it seems almost impossible given your confidentiality and the various things. But it's something that, as Siddharth pointed out, something that requires a real serious think through in a lot of issues. But
I think you need somebody to be an embedded insider in an arbitration chamber and then identify what's going on, right? Or you need to be a full-time employee with one of the arbitral institutions and give data for that institution. But there is interesting work. There is interesting work on the sociology of arbitration, which is being published elsewhere. Right? Okay.
Hello. So my question is regarding the, as you talked about credibility of judges. No. My question is regarding judiciary. So, shan't even the 4 Supreme Court judges who came out also was relating to assignment. So for assignment, shan't the judiciary outsource the work to some private agency, even if they have appointed who can assign the judges better, the benches better as per the specialization of the judges?
So more than who does it, I think the real problem is how they do it and on what principles. The thing is, we are dealing with a 21st century context, and we're trying to run a judiciary in 21st century context in 19th century rules and principles. The Supreme Court can't run anymore on just the discretion of the Chief Justice. I think that is what has to end. Now, what should be replaced by is still not very clear. Does it mean all 30 judges of the Supreme Court should sit together and prepare the roster? Does it mean only the collegium should sit and prepare the roster? Or as you suggest, an external entity prepare the roster and give it to the Chief Justice? Whatever the procedure, the second thing is how it should be done. Now, we've got good models at the High Court level. If you compare the recent roster put out by the Supreme Court to the ones put out by the Bombay High Court, Delhi High Court, Karnataka High Court or the Allahabad High Court, it looks like somebody scribbled something on a paper and tried to pass it off as a roster. Because these courts actually put thought into what goes into a roster. They divide up case on the basis of subject matter, sub-subject matter. They divide up case on the basis of year. They divide up case on the basis of the nature of the litigant. So there'll be stuff like senior citizens cases will be listed before this judge one day of the week. Or cases pending for 15 years will be listed before this judge 2 days a week. They put some thought into that roster. The Supreme Court has 11 categories split across 13 benches. That's not a roster. That's just basically something to, that somebody came up with overnight because they had a deadline. So I think more than who does it, the real question is what procedure should be followed and what should be the basis on which a roster should be prepared. Yeah.
So I'm Parika Kamra from 4th year. My question is, Chauhan sir mentioned a suggestion about establishing National Court of Appeals. So do you think that can be an effective solution in instituting the constitutional?
No, I changed my mind about this. I'll be honest. We started a project to say why a National Court of Appeals would be a good idea. By the end of it, we felt it'd be a terrible idea. And the reason keeping it down as an idea is because it still is an issue to appoint enough judges to the Supreme Court as it stands with its 30 capacity. Now, if you want to add another body with a 60 judge capacity, let's say, all right, even if you take 15 judges from the Supreme Court, you still have to appoint another 45 judges. Now, all you'll just do is transfer the Supreme Court's delay problem to this body. It may help in the sense that the constitutional cases will go to the Supreme Court, but what it will just do is create another opportunity for appeal or another opportunity to file a writ. As he put it, Siddharth probably pointed out very rightly, for a lot of people, SLP is a matter of livelihood. You file SLPs for your livelihood rather than to resolve cases. Similarly, we're going to find that's going to happen. Because see, supposing you have a National Court of Appeals, right? It cannot possibly decide every constitutional case. It will decide appeals from high courts. In some appeals of high courts, you will have constitutional questions arising. So now you'll get one more level of appeal in those constitutional questions. Do you want to create another set of appeals for this issue? These are a whole range of issues. This is something that, we've dealt with the arguments in our report on effectiveness and efficiency of the judiciary, but very briefly, this is one of those things that I've changed my mind on, because when I started off, I thought this is a great idea, but the more I looked at it, the more people I spoke to, the more the data sort of said, I thought it wasn't going to work.
Yeah, no, but just to look at the normative possibilities, you could have a situation like Germany, right, where the decision of the administrative court is final and you don't have a remedy to the constitutional court, or the decisions coming from the private law forums end there.
Yeah.
And the constitutional court is basically a body staffed with people with academic backgrounds to only look at, let's say, questions of rights or questions of structures of government. So hypothetically, it's possible. It may not happen given our current structure and given our staffing problems, but it's still a normative possibility because it has been tried out in other parts of the world. Yeah.
I was only answering in the present context as a solution to things.
It's very interesting to see some data-driven work. I just had a couple of questions. One on statistics. It's great to see so much data-driven work, but don't you think, like, for example, your last slide, a lot more level to where exactly is going up or going down if you take a picture, because we really don't know enough studies which have laid this out, because litigation in Punjab and Haryana may be very different from say, litigation in Orissa, Bengal. Which takes me to the other issue of statistics. I mean, why is it still so difficult to get out judicial statistics? There was one effort, legislative effort by Fali Nariman in 2004. But what do you think can be done on that front to force the government to set up a better institutional system to start generating proper statistics which actually help us in understanding how the... Yeah. The second question I had was, rather than focusing so much on Article 136 in the Supreme Court, do you think another way of looking at judicial reform is reworking how high courts work? Because the sense that I get in a lot of high courts is both lawyers and litigants aren't happy with the fact that, there's a two-judge bench hearing the matter and then straight, your only option is to go to the Supreme Court, or in some cases, only a one-judge bench and then you go to the Supreme Court. So maybe we need to think about reforming how high courts work to instill more confidence in litigants. Yeah. Maybe have a mandatory appeal to a 5-judge bench of the High Court and people feel a little bit more secure about having a fair hearing.
So I'll just go through that one by one. Yes, absolutely. I want more people to do data-driven research on the points that I've raised. Please disprove me. I don't mind that. But I want people to do much more granular stuff. Look court by court, high court by high court. Say this is absolutely right or this is completely wrong. I'm more than happy to be proved wrong on this. And I think, but it's more about using this method. I find too many of our discussions related to the law in this country are driven by, I think, or I've heard, I have seen, and that's very annoying. I wasn't there, but our friend Vikram Raghavan told me of the time, very recently, when Mr. Madhav Menon said, oh, please stop all this data-related nonsense. This is dangerous to our courts. This is dangerous to our democracy. I'm going, what? What? Are you kidding me? Yeah. In what way? Right? In what way? I mean, see, the thing is,
I think the specific conversation, if we can share it with the others, is that that some of the data was showing a correlation between caste background and adjudication. So, in Professor Madhav Menon's opinion, the founder of the NLU system, that was a divisive method of research.
Yeah, welcome to India, 2018. No, but yes, I think it needs to be done. Second point is, why is judicial statistics bad? It's a problem across the country. It's not just judicial data, and I think it is a very rare instance when some government-driven data is actually very good. The other thing that I tap, the judicial data seems like the hallmark of clarity when you compare it to NCRB. NCRB makes me tear my hair out once every few months. When I have an interesting idea, I want to follow it up. I look at NCRB, I see all these scanned PDFs put up on the NCRB website, and I spend 3 hours crying. So it's this thing, but I think we have to stop relying on the government for a solution on this. It will take a generation to fix, but the problems are. See, the thing is, it's not as big a problem in and of itself. It feeds other problems, but I think if we can find a fix for it in the private sector, and I mean individuals, universities, academia, public policy organizations, tackling that problem in some way, I think it might help rather than waiting for the government to come up with a solution. I don't think that's happening in a whole generation. Sorry, the third point, you had something, you had high courts. Appeals rate from high courts range from 1% to 10%. And that's linked geographically. Nick Robinson's paper sort of shows this, which he breaks down the appeals rate to the Supreme Court from the high courts based on state. And you find that the further the state is from Delhi, the higher the rate of appeals. In Delhi High Court, Supreme Court is literally the case, it is literally Ghar Ka Murgi. Which is why I think it won't make too much of an impact. I think people are still being limited by geographic distance and the cost rather than the quality of the adjudication. See, quality of adjudication, there's already enormous scope for improvement. I don't think that will fundamentally change the number of cases which go to the Supreme Court that much. But again, and this is a great point that Siddharth made, which I couldn't refer to in my this thing, is that judges are comfortable dealing with certain kind of cases. If you are a judge who's been elevated to the High Court as a civil lawyer, you spent all your time in the High Court dealing with mostly civil matters, mostly local body issues, and you suddenly find yourself in the Supreme Court as a result of seniority, you are going to be lost if you're going to have to deal with complex criminal, tax, and constitutional cases. So you will say, okay, fine, I understand these cases, I'll issue notice in these cases. The rest I'll just, or I know which kind of cases need to be decided by the Supreme Court in this area, so I'll dismiss all these. But in the others, if I'm given the roster, I'll just issue notice because a famous lawyer is before. So that's one of the things that I think is a bigger issue.
This is Sughosh from second year.
Yeah.
Two specific questions. First, with respect to the subordinate judiciary, do you think an all India judicial services would work?
No. I'll explain when you finish the second question.
Also, within the 3.24% of PILs that are filed in the Supreme Court, a lot of them are frivolous. For example, a PIL asking Pokemon Go to be banned because there were eggs in temples. So, can there be a better mechanism to ensure that these kind of cases are not addressed by the courts? And finally, is there any way of ensuring that High Court and Supreme Court judges are appointed with respect to the caseload that the courts have with respect to specialization?
So, just to answer the first question, I think we should stop talking about the All India Judicial Services at all. It's been a debate that has gone on for about 60 years. We are nowhere closer to an AIJS than we were in the 1950s. And the basic idea behind the AIJS was that we will create something like the IAS system for judges. Thing is, if it is an answer to the problem of capacity, right? The UPSC also is not able to fill more than 80% of total posts. 20% are vacant after many years of all of that. So you're left with approximately the same levels of ability to fulfill capacity. Same order of this thing. The thing is about 70,000 posts under the Group A category. There are 20,000 posts of this thing. Same problem. Capacity doesn't address the capacity problem. As far as the quality problem is concerned, this is a point that Siddharth also made. Now, people are not okay with joining the high courts because you'll end up getting transferred somewhere. Now, at least with the high courts, you end up getting transferred to a large city. If you're going to go from rural Karnataka to rural Bihar, you may as well go to a different country, right? It's hard. A lot of people are put off, by the way, joining the higher judiciary also because of the transfer issue. Because, you know, it's hard to, if you have a young family, if you're in the 30s and 40s, it's hard to suddenly go from a city where you generally built your practice to, you know, the middle of rural India and handle regular theft and murder cases and small civil disputes again and again and again for the rest of your life. So, the quality, I think, is not going to suddenly improve just because you have a job which can make you transferable anywhere across the country. There's a problem with the AIJS also because at the moment, you don't need too much special training for your local language, right? And most of the proceedings in trial courts outside the major cities happen in the local language. Yes, IAS officers do have a mechanism for learning the language that they pick up, which helps them deal. But with the judiciary, you have to figure out nuances of that language. You're not just giving them orders. You have to listen and understand, which I think is a much more difficult task, to be honest, than, say, being able to converse with someone because you have learned that language. So I think it creates more problems and it doesn't really solve a problem. So let's just give up on the idea of an AIJS. It is not happening. There was a couple of other points that you did. Public interest litigation. The solutions are in front of us. Nobody's interested because everybody likes to read about themselves in the next day's newspaper saying this public interest leave petition was dismissed by the court stating that it is important to protect the freedom of speech and expression. There is a built-in incentive not to take such systemic action because a PIL gets inevitably reported the next day. And actually, I suppose the media said we'll stop reporting Manohar Lal Sharma's stupid PILs in the Supreme Court, he might stop filing, and we've already found the solution. The third thing that you sort of said was? Appointments based on specializations, it's difficult. It's difficult because some specializations are really, really tiny. So the tax bar is really tiny. The criminal bar is really tiny. We may think that, oh, criminal cases are so often, but lawyers who can handle criminal appeals, lawyers who can handle tax appeals are very few. And you may either end up gutting the tax bar in that high court or gutting the criminal bar in the high court in trying to make appointments. So it may not, you can get one or two, right? You can get maybe one or two every 4-5 years, so that you have a constant stream of tax lawyers and criminal lawyers who are on the bar, but you can't really pick up too many people from that bar to staff the high court, because that kind of specialization is not very easy to acquire, and you don't want to cripple the bar in the process of helping the.
No, if I can just quickly add, so on the point on public interest litigation, I think the point which Alok is making is that the nature of media coverage gives us the impression that PILs are an important part of the docket. But as you become an insider, you realize that the actual time and attention devoted to PILs is not as much. So for instance, like he said, we are more likely to read about a PIL that is filed rather than an ordinary civil case where a substantive judgment has been given on merits. So for instance, what tends to happen is all kinds of outrageous PILs might be filed, but for example, in the Supreme Court, the filtering system is quite rigorous, right? You have to, there is a particular registrar appointed for screening PILs, the letter petitions which come in. Then there is a judges committee which screens them, and eventually the matters get listed before the regular benches. So in fact, both the data produced by Vidhi and older work is showing us that PILs are not even 1%. Of the docket of the court, right? So in fact, in Alok's chart, you saw that percentage figure of 3.2% for writs. So PILs are a small subset of that percentage. So I think that confirms the sort of argument that we might be over-prioritizing the critique of PILs when we think that PILs are clogging up the courts. They're not really the problem, right? It's a bit like saying that during your 5 years in Nalsar, you'll remember the most scandalous incidents. But those scandalous incidents may not really have an impact on you or the institution's future in the long run, right? But you remember your 5 years for those incidents, right? So irrespective of what happened, right? On the last point about appointments and allocation, so I think most high courts, as Alok was explaining, do have an allocation system where as a filing advocate, you know which bench is more likely to hear a certain matter, right? Usually, especially Delhi and Bombay high courts have a pretty elaborate roster, and you can actually accurately predict which bench is going to hear it. I think the problem here is what happens when you have too many generalist judges who are hearing cases in which they don't have a background or they have a real cognitive problem. So I think that's what Alok was talking about. So can we really solve it? It's a difficult question, because if you start making an argument for specialized appointees, then the argument is you'll end up appointing judges who have a very narrow frame. And in the longer run, when you're looking at appellate litigation or even constitutional litigation, you possibly want people to bring a bigger picture when it comes to making such decisions. So it's not such a simple exchange of specialization versus generality, right? There are good arguments for both, right?
And just one point, even specialist judges, they hate having to be on the same roster for more than 3 months max. This is one of the things we realized when we were working with the Law Commission on the Commercial Courts Bill. We said, is it possible for a judge to be on the commercial side for 2 years? They said no. And these are some of the smartest judges, these are some of the most hardworking judges. And they said, any roster which we are forced to sit on for 3 months, more than 3 months, becomes a chore. It becomes a complete chore, and they'd rather, deal with different kinds of cases they're not heard before. So that at least, it expands, as Siddharth was making the point, it expands their horizon about these things. And I think we don't want to over-specialize the judges too much as they go higher up the chain.
Yes.
Yeah.
Hi, sir. I'm Angat from the third year.
Yeah.
So when you compare the data of number of cases filed on the civil side via the criminal side from I think 2005 to 16, you inferred that where people have a choice, they are not going to the courts.
Yeah.
And this voluntary choice to refrain from resorting to courts for dispute resolution, you have attributed to loss of credibility in the institution.
Yeah.
And as Professor Chauhan has already preempted what I wanted to raise, but can we attribute the stagnation in number of cases filed on the civil side to simply loss of credibility in the institution? Delays, costs of litigation, more importantly, newer forms of dispute resolution having emerged, and also courts themselves having encouraged the use of ADR. So can we really say that the credibility of judiciary is under threat? And I mean, is this? I mean,
So,
does this go on to indicate that the future of judiciary is weak in India?
I would say the first two are also linked to credibility. See, because if you are going to a forum which can't deliver, see, it has to be one of the two. Either it has to be that the forum delivers quick justice, even if it's a little bit more expensive, or you take your time, but it is very cheap, right? The cost for you is minimal, but it can't be both. It can't be high cost and it can't be delay. Delay is also a form of cost. To be honest, delay is a form of cost itself. So I would say those go into credibility. I didn't have too much time to deal with that aspect of delay because I have more charts if you want for delay. But I would say delay is also an aspect of this. Delay is an aspect of the credibility because if you're not able to decide in time, if you're not able to pass judgment or provide effective relief in some way in time, that affects your credibility as an institution. As regards ADR, there is a significant chunk of Indian commercial cases which are being handled in Singapore. That's true. So yes, to an extent, yes. But those are very high value stuff, right? They will not show up in the volumes that I'm looking at. A lot of, I mean, it's more or less standard to choose, I think, if it's a certain, above a certain threshold of a transaction, it's more or less standard to choose Singapore, London or Dubai as the place of arbitration, not even India. And that's mostly because they're like Indian courts are slow, Indian courts are too interfering, and we'll never get the kind of professional dispute resolution that we are sure in these other countries. So yes, ADR partly, but it doesn't explain the full volume of cases. Mediation, and I think Siddharth also pointed very only in the large cities, mostly in the context of family courts. So it's not something that again explains the volumes that we are seeing falling. And likewise with tribunals, even the new tribunals over the last decade or so, at most you may say in the order of tens of thousands, but not in the kind of lakhs of cases we are not seeing, right? I suppose we should have had many more cases filed per year in the High Court and in the District Court level than we are seeing currently. But even if you say these have channeled out of the courts, I'm not sure they provide a full explanation. There's another area that you didn't mention, and that is using criminal law to handle civil disputes. This is happening in two areas. One is basic money recovery. Instead of filing a suit to recover the money, people are filing fraud cases. Unfortunately, the courts are encouraging this all the way up to the Supreme Court. There's basically, so I mean, I again wrote about this for Ken, but very briefly to summarize the main point. Yeah, an older category was dishonor of checks. The newer category is use of fraud, 420. You will have a case where suppose I owe you 2 crores. You find that I may not pay in time. You will file a criminal complaint against me, get an FIR registered saying I've committed fraud. It's a non-bailable offense. I'll have to go to court. In court, you will come and say, please don't give him bail until he deposits at least 1 crore in the court. Forcing me to actually pay you 1 crore in court. If nothing else, that will settle the matter between us and I'll get bail on that basis and we'll put an end to that dispute. But people are misusing criminal, and the problem is technically 420 is not a compoundable offense. Under the CRPC, 420 is not a compoundable offense. You can't settle the offense between yourself and say it's done. But courts are still allowing such settlements. Courts are recording such settlements and saying we quash the charges on this basis. So a lot of such, if you look at the NCRB data, painful as it is, 2005 to 2015 has seen a doubling of the number of fraud cases in India, more than every other category of cases. The only other comparable category of cases are kidnappings. I mean, you'd think, wow, has India suddenly discovered a huge cartel in the kidnapping industry? No. Every major kidnapping, the explanation for a lot of kidnapping cases simply is intercaste marriage or family issues. Parents who get into a domestic issue, one parent will take the child and leave the country, the other will file a kidnapping charge. You want to stop your children from undertaking intercaste, interreligious marriage, you file a kidnapping charge against the groom. If you get a day or so, just sit in the courtroom in the Delhi High Court, which is handling criminal miscellaneous applications. You will find one such case a day, almost, where judge goes, okay, what is this about kidnapping? Oh, it's actually a love affair where one person has eloped with the other. Is the groom here? Yes. What do you do? Okay, you're working. Is the girl here? The girl is there. Do you want to go with him? She says yes, because I'm in love with him. What do? Are you earning enough to support the both of you? The boy says yes. Bail granted. Immediately, the family of the girl or the boy start howling in court, going, "No, this is our child. How can you do this? Don't do this." I'm going, what just happened? What just happened? But it actually happens on a pretty much daily basis. So every high court, I only know Delhi High Court. So yeah, yes, yes, yeah. Yes. So you find that instead of regular civil disputes, people are resorting to criminal.
Another question to Chauhan sir. When Alok sir says that even delays and costs are linked to credibility of an institution, here are we confusing criticism of the institution with credibility?
No, I would actually go with what Alok is saying, because invariably if you have see, for me the representative example is a family partition suit, right? And I'm coming to it from some engagement with the anthropological literature on this. So sometimes a family partition suit will be closely linked to numerous other cases which are likely to be filed between the parties, right? If it's an agrarian family, there will be connected criminal cases. There will be multiple suits depending on how many generations have come up. So I would say in such scenarios, delay is a serious concern, right? If you realize that your civil suit that was filed in the 1960s is still unresolved, then eventually at some point you will forego the possibility of appeal, right? So I think he's onto something there, that it is clearly linked to the question of credibility. But I think it's the other aspects which are more interesting, which is that can we explain the decline in the rate of civil litigation by looking at the rise of alternative forums? If not, to what extent is that possibly adding to the decline, and could there be other reasons which we need to explore? So I think that's the interesting trajectory that he's picked up.
And if I may add just one last point, in most of rural India, in fact most of India, either a property dispute ends up as a murder, or the seed of every murder is actually a property dispute.
And there's some fascinating work from the 60s. Including work by Bernard Cohen, who had done field work in Shamirpet in the late 1950s and studied the panchayat's functioning. Anyway, so I thank everybody for showing up and sitting through. 4 years ago, if somebody told me that Nalsar students will sit through a session on empirical legal research, I would have laughed. But things do change, and hopefully they'll change even for the better, even sometimes at the cost of coercion. Right? So I thank Alok for making the trip here. Thank you. And I hope some of you are already part of our project on Supreme Court cases, but we do hope to expand the range of research with the passage in time. Data collection is a hard process. It takes years sometimes to unearth meaningful data. And then, of course, interpreting it and explaining it in a manner that is accessible to a broader audience is part of our mandate as a law school. So as long as some of us are around, right, there will be opportunities to do serious empirical legal research in this campus as well. That's the assurance I can give you. Right. Okay.